All right, it is 2:01. Call the meeting to order. First item of business, pledge of allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Of all board members present, open it up for public comment on non-agenda items. Anybody here that wishes to speak on non-agenda items?
We have not received any.
On agenda items, I have one registration form here from Paulina. Is there anybody else that wishes to speak on agenda items?
I'm sorry, yes, sir. Lynn Sherman.
Okay,
I guess in advance of agenda item number 6.
one of this minutes, I have a form. Do you want to go before or after? Or does it matter?
Probably doesn't matter.
Go ahead.
Oh, yeah. Thank you. I'm Lynn Sherman. I represent the Texas A&M University System. And I'm responding to the, I guess it'll be agenda item number 6, where y'all are going to be considering an executive session. A number of the upwell permits in their landowner that were considered back in the 2023 timeframe during a period where there was a lack of a quorum of the board meeting. Just to be really clear and direct, the Texas law is very, very clear that a governmental entity cannot retroactively fix a violation of the open meeting. It's very clear. And the only way to fix it is to have a new meeting. We provide y'all with some information. We think that our recommendation is that the only way to make it right is to have a new hearing. We've already got the ability to send it to the State Office of Administrative Hearings. And our recommendation is that y'all do just that, is to take the permanent applications, send them to the State Office of Administrative Hearings for all proceedings. We'll come back with a proposal for decision that this board can consider. It'll be done by one of the state's professional administrative law judges. It'll be a good product that you can then make your decision based upon. I think it's the easiest way to get things fixed. And you also get the input, get some input, really valuable input from a professional. I also want to point out that doing this will be consistent with, it would be a result that's consistent with pleadings of the district itself as pled in Brazos County. And also, interestingly, given the way the case has developed in terms of the parties, it also is consistent with proposals or positions that Upwell itself has taken relative to some of the other permits. Just send it to SOA and let SOA do its work. Thank you very much.
Thank you, sir. Pauline?
So I'll make some initial remarks and then we'll also respond to Mr. Sherman's
All right.
characterizations of some of what's gone on here. Paulina Williams, good afternoon. Happy New Year. I hope you all had a good holiday. I'm speaking on behalf of landowners in Robertson County, including Lutzes, Skiles, Zinos, Holshers, Bryan, Moore, and UW Brazos Valley Farm. And we've submitted comments to you previously, some of which Mr. Sherman has referred to, explaining how, but from our perspective, the district's rule from September is clear. It's in alignment with your original intentions for that rule, and it would shut down efforts by Texas A&M and others to improperly destroy permitted property rights in this district. This district has explained that the rule was adopted to ratify, not restart. That's a quote from your filing. Ratify, not restart the permitting process on affected permit applications related to the officer question. The law is clear that there is 200 years of precedent validating your actions, and that there is a rule that you have the authority to adopt that applied even-handedly to all members of the district solves this issue. We can agree that the law is clear on that. We do not agree with Mr. Sherman's characterization of the law. With a plain language reading of the rule you adopted, the district's actions and its final permits are respected, and your governmental power, the power you are wielding over landowners in this district, is exercised fairly and consistently with your stated intentions. So we ask you to stand in the shoes of the landowners as applicants who came to this district, applied for permits, complied with all of your rules, jumped through every hoop associated with this governmental permitting, made compromises requested by this district, made investments of their resources, and built chains of reliance based on those permits after securing final permits. And they continue to make those investments in good faith reliance on the law. We asked the district to reject Texas A&M's untimely hearing requests on final permits, even-handedly ratify all the permits signed through the general manager's authority under your rule of 8.3J, and restore the status quo that the district says it had intended. And that is consistent with both common law and your rule, which you had the authority to adopt. We understand that the district would like to see resolution of all these disputes, and we too would like that. And we have made good faith efforts to do so. And unfortunately, the district's silence here has emboldened certain parties and not brought the parties together. We made a proposal in October for settlement, and we thought we were making real progress, and we're getting very close. And in over 2 months, the protestants have not responded to our proposal, which was more than a fair one. The district treating all the permittees the same under the same ratification rule not only is consistent with the law and its plain language and its fundamental fairness, and with your authority to have adopted that rule, it would give the clarity needed to bring oppositional parties to the table. So in response to some of the characterizations of Mr. Sherman, this district did not take a position in that hearing in front of the judge about the de facto officer doctrine or about fundamentally what actions have happened by this district in relation to their hearing request. It's improper to send untimely hearing requests on finally issued permits on which there has been reliance and which you have both a rule and a common law remedy to solve. Taking down and destroying the resources, the time, the effort to exercise state recognized, district recognized private property rights that were brought here in good faith by the landowners of Robertson County is not simple. It is not required by the law. It is not something that is easily dismissed to the State Office of Administrative Hearings. That is a game they are playing to delay and throw a cloud over what should have been handled and wrapped up and tied with a bow to clean up what was a ministerial mistake at one point by this district. It is not a chance to rewind the clock and sow chaos. There are millions of dollars that have already exchanged hands in reliance on those permits. That is why the law protects this board's actions. And we ask you to stand behind that. The simple answer is you can look just at your rule. You adopted it. You had authority to adopt it. It does what you needed to do. That is also consistent with background principles of common law. So we ask this district to stand behind its actions to protect what it has done in the past, which aligns with protecting the private property interests of landowners who complied with spacing, production limits, and everything that this district asked them to do. So we ask you to treat us fairly and do the right thing here, and we appreciate your time. 2 final points. To emphasize our objection, we continue to object to the city's representatives participating in any deliberations and action regarding permits that are associated with the transport project. The cities are both litigants and protestants, and recusal is needed. So that is a standing objection at all times. And I also just will point out for your files, we have filed that motion for reconsideration regarding the export fee portion of your rate order, and we're happy to answer questions as to that motion for rehearing as well. So I thank you for your time.
Thank you. Anybody else that wants to have comments on agenda items? None? Move on to item number 1, election of officers for the 2025 calendar year as required by the district bylaws.
So your district bylaws state that the board shall meet and elect new officers annually at the first meeting following January 1st of each year. The board also will fill any vacant officer positions as needed. And adhering to that, today would be the first meeting after January the 1st. So you need to duly elect your officers. Current officers are Jason Barfnick is president, Jerry Mackler is serving vice president. Secretary is currently Jeff Kennedy, and treasurer is Chris Zyde.
All right, we'll start off with the president. A call for nominations for our president.
Yeah, I nominate.
Say again?
Yes, Mark.
I second that.
Anybody else? No? All in favor, say aye.
Aye.
Any opposed? Aye. Moving to vice president. Call for nominations.
Nominate Gary Meckler.
Second.
Have a motion and a second. Everybody in favor, say aye. Aye. Any opposed? Motion carries. Secretary? Call for nomination.
Thank you.
Have a nomination, Jeff Kennedy,
I'll second.
and a second. All in favor, say aye.
Aye.
Any opposed? Motion carries. And last treasurer, Chris Zeig.
Nominate Chris Zag.
Second.
Motion and a second. All in favor, say aye.
Aye.
Any opposed? Motion carries. Item number 2. Discussion and possible action on the minutes of the December 12, 2024 regular board meeting.
That's for everybody. These have been posted since, I guess it was Friday, that everybody should have the minutes of the December 12th meeting in your packet. And you see anything that needs to be revised, please let us know. If not, I'd ask that you adopt the minutes, approve the minutes as presented.
Make a motion, we approve the minutes as presented.
Second.
Have a motion and a second. All in favor, say aye.
Aye.
Any opposed? Motion carries. Item number 3, financial report, December 2024.
Okay, quickly through this will be the last financial report, final for December of 2024. Total deposit at $64,628.42. You'll see that we balance out on our on the balance sheet at $1,568,999.03. Moving on to our budget expenditures, total income for 2024 was that's fees, water production fees, application fees, and then our interest on CDs. And then we have, so you'll to remind you, there's $68,862.67 in other. I believe it's about 45,000 of that is money that has been put up in, I'm gonna call it escrow, but it's in our account to be paying SOA for the current SOA contract. So that was put up by Upwell, and that's in our account. So total income shows to be $910,017.10. Our total expenses for the year was $1,125,144. And we were over by just over 29% over budget. And as you know, most of that was in legal and or hydrogeological. Then we go on to your collateralization report. We are currently at 121.7 days on our weighted average maturity. The percent of portfolio in CDs were nearly 72%, and on cash we're just over 28%. Collateralization at level at Prosperity Bank's 181%, and at South Star's 169%. Last two documents there are our expenses by vendor. In the normal account or the operating accounts at $111,769.35. And you can see that we did make the first payment to State Office of Administrative Hearings. So you'll see more of that as we move forward. And we had one check written on, or one transfer on the well assistance fund of $900. That was some of John's pay. So, and had a little interest. Any questions on the financial report?
Any questions from the board on the financial report?
If not, I'd ask that you approve the financial report as presented.
Entertain a motion?
Move approval. Second.
Have a motion and a second. All in favor, say aye.
Aye.
Any opposed? Motion carries. Item number 4, we're gonna skip.
That's correct. I left them, I told them to stay in Waco. It was supposed to be having a wintry mix.
Item number 5, discussion and possible action on revision of the contract with Banning Masonry to repair and water seal the western brick wall of the district office.
So quickly, after December 12th meeting, I was authorized to enter into a contract with Bank Masonry to make the repairs on the wall. That was $9,900 is what they had, the bid had been, proposal had been. And you gave me a leeway of $3,000 because we were talking about sealing, water sealing the wall after it was once done. Having talked to Bannick, they had sent me originally said they would seal the wall for an additional $10,000. I said, we got to rethink that. Had him rethink it. I talked to our neighbor over here, Travis Laycox. He had a water sealant, nearly a full tote of it across the street at Ace Hardware. He'd bought the tote, only needed a couple of gallons. He thought that's what he was buying. He bought 250 gallons. So made a deal with him. He'll sell us that surfactant out of that tote. Went back to Chad. Chad will do all the work for the extra $3,000, and then we provide the material to seal it, and that's going to be between $400 and $500. Okay, and that's getting enough sealer for doing it now, and then be able to come back because at some point in time it'll need a second application. That doesn't mean next year. It might be 2 years, might be 3 years. But it's an organic, natural product, so it's going to break down over time as the more sunlight, that's just going to have a breakdown. So the suggestion was to go ahead and buy enough to do a second application when it came. That's where the $450. I'm prepared. I'm asking that we enter into and sign that revised contract for the 12,000, I guess it's 12,200, and then we provide the product.
And for clarification, the additional product that you want to buy and store does not break down over time and
So, I'm sorry, say one.
there's no shelf life on the material,
That is
the
correct.
additional material that we're
That's
going to buy.
correct. That is correct.
Any discussion from the board? If not, entertain a motion.
Move that we authorize the general manager to enter the contract.
I'll second.
Have a motion and a second. All in favor, say aye.
Aye.
Any opposed? Motion carries. Item number 6, executive session. Under Texas Government Code 551071, receive attorney-client privilege information regarding 1, pending transport permit applications for groundwater from the Sinsboro Aquifer for RH20 LLC, Clifford A. Skiles III, for James C. Bryan, for L. Weiss Moore LLC, Vizino Investments LP, for Eli Family Partnership LP, and Cula de Brazos LLC, all of whom are co-applicants with UW Brazos Valley Farm LLC, ongoing settlement discussions and related mediation by the State Office of Administrative Hearings as required by District Board Order Number 1. Pending contested permit applications for groundwater from the Sinsboro Aquifer for Clifford A. Skiles III, James C. Bryan, Eli Partnership LP, RH20 LLC, for Vizino Investments LP, and for L. Weiss Moore LLC, and for Cula de Brazos LLC, and for UW Brazos Valley Farm LLC. Pending writ of mandamus filed by Texas A&M University System in Brazos County District Court. District Rule 8.3 regarding the permitting of wells. Pending lawsuit of Azino Investments LP versus Brazos Valley Groundwater Conservation District filed in the United States District Court for the Western District of Texas, Waco Division. Water production, export, and administrative fees, and groundwater conservation district related issues in the 89th Texas Legislature. At this time, the board will go in executive session. Yeah. We're ready. All right. It's 10 minutes after 4. Board is coming out of executive session. Do we have any motions coming out of executive session?
I can make a motion that we set a hearing on representatives systems pending claims on its mandamus.
Second.
That's the clarification. Who's speaking? Council for the district. The judge might want to set a trial as opposed to a hearing. That I would suggest just a friendly amendment to that motion to say a hearing and trial. The motion that trial and takes the system's permanent defense and spending.
Second. The motion and a second. Discussion. Say aye. Any opposed? Motion carries. Any other motions coming out of executive session?
Yes, this is related to 3 resolutions adopted in December. Resolution adopted in December 2020 to be amended. The state that a production permit is permitted for multiple uses. They are assessed with the production fee rates, then the highest production rate is applied. They're fast. They're fast.
That's it. A motion and a second. Any discussion? All in favor say aye. Any opposed? Motion carries. Item number 8, general manager's report.
All right, pretty quick is, they've got here from, you've got your monitoring, drought maps and, it continues, I don't want to complain today or not, but it's, it hasn't been too bad around here. It can be better. I'll leave it as it is and y'all can look through the maps. I did send that to you via email, this morning. Moving on to the, permitted wells, again, this is just an overall look at all production, a year from 2019 up to 2023. You'll see 2024 coming in the next year. I'll have them, and then you see what the matters and all that. Then on to the next one, which is permits as general manager, and that was at none in December. 2,668 that was permitted last year out of board, and the year before, I think the road was 200,000. So, just Aaron. Then the next is the mitigation management completion zone. The only thing there today is we now have 364 wells in the list that are either identified absolutely as simple wells or still need to be touched. Most of those will be simple wells, and we're trying to get that one wrapped up. It's project. Hopefully we can get done by mid to late March. On to the next, which is the DFC planning update. We did have a meeting on December the 3rd. Discussed three last factors, which were environmental impacts, social and economic impacts, and private property limits. Got that all discussed. Nothing much more changed, but I did advocate, as y'all asked me to, that we would have equal payments of 32% as we cost share on the planning between Brazos Valley, Lost Pines, and also Savannah, with 2% on each of Mideast, Texas, and Fayette counties. Lost Pines was going to have to go back to their board, and I guess we'll hear something in late February when we come back to the next planning. And on that next page, it talks about the DFC workshop and stakeholder meeting. We're getting ready at the June 12 to get off into the serious modeling and what the company that kind of thing. James and I that links this week, and I ran it up with Jason about having a DFC workshop, and also have let's get the stakeholders in and let's get some feedback from them as to what they think that the DFC needs to look like. What the parking files need to be. So soon you're going to have to develop. You've seen one developed model. We gave that to you, James and I did, and that we thought was the best crystal ball estimate. And when we ran that, it took our DFC down from Central down to like 330 feet. Okay. And what any of the other districts might do with that, there's no indication. The long story short is, if we get the feedback from everyone, we will have done our due diligence, and it's going to give you some a good ground to be able to say, here's what we want to do. We want the DFC to go higher. We want it to stay exactly the same. Whatever it be. So I'm suggesting that you have the workshop. There's two ways we can go about doing it. We can either hold it independently, and I have James give me several dates between now and the next board meeting, which is on the 13th. I think it's going to be a 2-hour thing, probably. I don't think it'll be any more than that. And so we can do it on a date between now and then, or you can hold it on right before the board meeting the next time, just like we did the budget workshop, or any other type of workshop. So I don't know. I'm telling you hear what y'all's thoughts might be. But I think to me, it's an imperative and important thing to have that, so that we can say, we've gotten to think of that. We've done our due diligence. So, anybody have any thoughts about it? Would you rather hold it right before and then have lunch like we did the last time? Put that in there? Or here's the pro to doing it independently is if you did it 2 weeks before, let's say, then you're James and I got enough time to process the things that have been said and then we can put it on to maybe the next board meeting, and maybe there's action. Okay, if you do it, it doesn't give you much time to get it on to February, but you might not be prepared to make any kind of recommendations that kind of. Not that that's imperative that we do that in February. Okay? It's not. We just know that in February, GMA 12 on the 21st, we're going to start talking about what runs do we need to do. And at that point, it gets more serious. So we could wait on, we could do it in February and then put it in March. So.
What's the list of the board? I remember tied into the board meeting.
So you really able to go to that meeting on the 21st, knowing where we stand versus it would be good.
It's not absolutely necessary, but nobody else can say, and here's where we are. There won't be a one of them prepared to say that.
Yeah, but that might be good for us to take the lead on it and say.
That's out.
Take it to do it a couple of weeks before our next meeting. That's
James to send me some dates, and we'll give you some dates that he suggested that he must be, he would be available. All right. The dates he said he was absolutely available January 21, 22, 23, 30, 31, 4, and what we can do is we don't have to make a decision.
So there's anybody on saying what's your.
That's exactly it. I can do that, and that's the way we want to go. I'll do that. All right. And then the next thing is, we have to go back to the legislative session. It's been a lot of bills, but
Monday morning, I did this next morning. Soon, all of those filed, but, so if you have any questions, let me know, I'm not going to start. About anything.
I haven't seen anything that is concerning. So,
And on it, I sent it to, the way that she's reviewed it. Questions about it.
so I'll add in the talk to the battle that next meeting that's Savannah. I have spoken with both of our representatives. I was in Huntsville yesterday and sat with Trey Wharton for about an hour and a half, and Paul Dyson, spoken with him at Thanksgiving. We sat over at coffee place, and we was called coffee something in Bryan, and that old house, and both of them are easy to talk to, and very open to what we do, and understand that we're very much needed in it. And I think that it's going to be very easy to work. So, take on that, make that contact. All right. And then the last big thing would be that we can see that the business of the district that we've been doing. It has been, the permitting is getting, I mean, excuse me, the fees, they're not really well. The first round, but we're hoping to avoid confusion because we've got to get the first 2024 out. And then these people are going to get 2025 right behind it. So we're trying to hold hands and kind of, but so far everything's good. I will tell you that there's going to be some people that they're going to talk up the permits. I don't think there's any doubt about it. And it's not that we intended for that to happen. It's just that is gonna be, there's gonna be a consequence. That is simple. Already starting to get a little activity on it. And, what you'll see here in the last one is our everything that we did, to meet our goals and the management plan. And the day that we've met all of the objectives. And at the February meeting, that will be one of the agenda items. And it's the report and the annual report.
All I got, guys. All right. Item number 9, discussion on any possible future agenda items. That have anything you'd like to agenda items? Yes. Item number 10, agenda. Have a safe trip now. That's on it. Yes.
And then.